I think we have everybody here. This is cause number 2025-00158. Barney Donaldson Jr. versus Jamie Harbour, DBA, Arise Church of Canton, and Edwin Voss, an intervener, City of Canton, Texas. We're here on the plaintiff's motion to recuse. Judge Martin, are the parties ready to proceed?
This is Joe Alfred Eisen Jr., who will be representing Mr. Donaldson for this hearing, this recusal hearing. I understand Mr. Donaldson has signed in. He signed in. We're ready to proceed.
All right.
Ed Voss here on behalf of the City of Canton.
Okay.
David Ritter here on behalf of the City of Canton.
Okay.
Joshua Alisi here on behalf of City of Canton.
Of Canton. Okay. My name is Alfonso Charles. I'm the presiding judge of the 10th Administrative Judicial Region, and I've assigned myself to hear this case. I do see that there was a motion, pro se motion filed by Mr. Donaldson asking me to reconsider my appointment. And it does, in that motion, it says that it is not a motion to recuse, and I'm going to deny that relief. I'm going to hear this. I have assigned myself. I am familiar with the parties and many of the accusations, so I think judicial economy dictates me hearing this. Also, Mr. Eisen, I'm just going to instruct you also, and to instruct your client, that since you are attorney of record for the purpose of this hearing, I'm not going to allow dual representation. You will be the one speaking on behalf of Mr. Donaldson. You understand?
I understand that ruling, Your Honor. I also call your attention to a motion that requested discovery. That may become something you take under advisement depending on the disposition of this hearing. But right, I'm arguing that for him because it has to do with the merits of this recusal and the way it should be handled.
I will carry that motion at this time. All right. Do you have a brief opening statement, Mr. Eisen?
Yes, I do, but I would request that in light of your ruling, you allow Mr. Donaldson a chance to confer with me, not excessively, but if he feels like there's something he needs to say to keep the record clean, I can confer with him on cell phone and get right back on if that's not too burdensome.
I will allow that, or put you two in a breakout room if need be. But yes,
and we'll strive not to abuse that or keep everybody going here.
All right.
With that, I'm ready to proceed.
All right, you may present a brief opening.
Now, I'm going to make an opening statement. Is that permitted?
Yes, I said I was asking you for a brief opening statement.
Yes, sir. I'm very familiar with the facts of all this, too. I sat here with another motion where I complained to you of administrative bias in another case. It was against New Beginnings Church, which I represent. You ultimately denied that recusal, but you stated, what about that hearing on contempt that they were entitled to have from this Houston injunction? And you never got a satisfactory response from City of Canton or its attorneys, and there never was a hearing. So I anticipate I'm fixing to request played before you a videotape evidence which my client received anonymously. It's in the nature of a whistleblower evidence, something that we've all become familiar with. And if this tape is authentic, at the end of this hearing, if there's questions about it, the questions need to be resolved. But we're proceeding here under the standard of impropriety, not the standard of strict admissibility under civil or criminal law or rules. Your job, and I'm just stating this respectfully, but as I understand what the standard is, your job is to determine whether there is such evidence that even if there's ambiguity concerning the value of such evidence, affidavits, other types of evidence that might not meet strict admissibility in regular cases, does that evidence establish with its ambiguity or its admission evidence of such impropriety that a reasonable person in the street could find that the justice system in Van Zandt County was unfair? This tape is my whole presentation of today because we have founded on the rule, which I've argued against, but which still stands, that a judge cannot be judged on his rulings. Even 100 rulings that seem unfair cannot be a ground for recusal. It couldn't show bias. When you get into the administrative area, this is what evidence we're fixing to play. I ask you to review it from the standpoint of administrative bias. That is, the court is already prejudiced against you before you enter the next case, no matter what the evidence is going to be. Now, I'll make an argument after we've been able to hear this tape, but I'm not going to belabor the evidence of Mr. Donaldson except to just ask him authenticity type or laying the predicate type evidence for getting the tape in. I request to go ahead and proceed on the video, discussing it with him as to authenticity that I circulated it to everybody. I did that as a courtesy, and I wanted them to have it before we started this proceeding. And so I'm assuming that it read well for everybody. I couldn't see it, I'm blind, but I've heard it. So it has an audible portion and it has a video portion. Now, Mr. Johnson has filed a declaration. He has filed a reply to Mr. Voss's response. The comments in Mr. Voss's response, they're intemperate or otherwise, about there being no evidence. We say there's evidence here with this video, and this is going to be up to you to be able to handle, and possibly Court of Appeals if it goes that far, and possibly Judicial Ethics Commission, and possibly other entities. Despite all this, I say that I stand on Mr. Donaldson's declaration. He's here and he's able to be cross-examined on the declaration if they want. I'm going to start my presentation simply with the video itself without playing it. I'm going to establish what I believe is the best evidence rule that we've got, the authenticity we've got, the predicate, and then I will proceed and request it be played, and then I anticipate that's going to be my end of this matter. So with that, I'll be allowed to proceed.
Well, I'm going to give Mr. Voss or Mr. Ritter or Mr. Galicia an opportunity to give their opening statement on behalf of the city of Canton.
Judge, would you like that now or after he?
You can either present your opening statement now or before you start your case in chief if you have one.
I'll provide an opening statement at this time, Judge.
Okay.
And for the parties. The motion for recusal was filed by Mr. Donaldson, asserting 5 distinct grounds, and I filed a response that addressed each of those grounds as stated in the motion, and I believe that the evidence attached to my response consisted of court filings in the underlying case, because the bulk of the recusal motion is focused on Judge Martin's rulings and an expression of dissatisfaction with those rulings. And under Rule 18A, that's not sufficient grounds for calling into question the judge's impartiality. After I filed the response, Mr. Donaldson filed his declaration. I've reviewed every paragraph in that declaration. There are 3 paragraphs that specifically address the video I believe that Mr. Eisen is getting ready to play. Those are paragraphs in the declaration on page 7 of it, 52, 53, and 54. There are 2 attachments. Attachment 13 to the declaration is the actual video, and attachment 14 is some kind of report that is presumably presented as some sort of authentication to it. I will be lodging objections to the video. I also note for the court's record and for the court's information that all the other paragraphs in Mr. Donaldson's declaration, without going through the detail of numbering them specifically, all the other paragraphs in the declaration are either irrelevant to a recusal motion. They're an attempt to collaterally attack the underlying stipulated judgment from the original case from 2020, and that collateral attack is unlawful, as I set forth in the city's response to the motion. They're also complaining of all the paragraphs at one time or another complain of Judge Martin's judicial rulings. Merely complaining about judicial rulings is insufficient to establish recusal. Also includes improper legal argument from Mr. Donaldson. Mr. Donaldson is not a lawyer and is not authorized to make legal arguments or present legal matters as if he is. And then lastly, several of the paragraphs include hearsay statements from other parties, for example, either Ms. Harbor or other people that he dealt with in the underlying case that he's dissatisfied about. So without belaboring all of that, I will be providing the court objections to the video and urging the court at the conclusion here of denying the motion to recuse and denying the motion for discovery, which can also address at the appropriate time.
All right. Thank you, Mr. Voss. All right, Mr. Eisen, you may start your case.
In light of Mr. Voss's opening statement, I request that Mr. Donaldson, who's online now, play for us the video that he has, and then I will ask him the authenticating questions, address best evidence questions, and establish the chain of custody of this video. I state that this is a judge. This is not a jury.
Hang on. Are you calling Mr. Donaldson as a witness?
Yes, sir. I wanted to play the Article 13 or Exhibit 13 Mr. Voss referred to.
All right.
With
Mr.
your
Donaldson,
permission, too.
if Mr. Donaldson, if you'll raise your right hand, receive the oath. Mr. Donaldson, if you'll raise your right hand, receive. There you go. Do you solemnly swear or affirm the testimony you're about to give in this case now on trial is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. All right. You may proceed, Mr. Eisen.
Mr. Donaldson, you have that video evidence that I circulated to the parties and attempted to get to Judge Charles and through the clerk, of which you can play it for us.
I have clicked on the request to share the video, and I have a message on my screen that says sharing is not turned on. The host is not allowing sharing for this meeting.
Is there any way we can play this video through Mr. Donaldson, Your Honor?
Let's see.
Now, I represent affirmatively that this is, as far as I know, and I'm blind, but this is going to be the evidence everybody can check that's already been circulated when he plays it. Thank you, sir.
Let me see if we can get her to.
Judge, give me just 1 minute. I'm trying to figure
okay.
that out.
Okay.
I think I have to do it. Judge did it. Judge will.
All right. It's now allowing screen.
Okay.
Are y'all able to see that?
I can. All right. See it?
I'm not, but I'll take everybody else's word for it.
Okay. There's no audio.
Were y'all able to hear it that time?
Yes.
Yes.
I request one more play, and then I will proceed to questioning.
Mr. Donaldson's still out in the hallway. Go have a deputy rough him up a bit. Maybe he'll go away.
I'll proceed on the questioning with your permission, Your Honor.
You may proceed.
Thank you, sir. Mr. Donaldson, did you just play an electronic recording that it contained a video and an audible portion of sound?
Yes, sir.
Where did you obtain this video?
Sent to me through Facebook Messenger from a man named Rusty LaFleur.
And how did you obtain Rusty Fleur's name from Facebook or from some other source?
It came to me through a messaging service. It's like text messaging. It's not directly on social media, but it's part of social media.
Now, for the uninitiated, which I certainly am, what's the difference between social media and somebody just uploading some video they want somebody to see on Facebook, if any, as you understand it?
Facebook allows public sharing of stuff so everyone can see it, and they allow private messaging between individuals. This was sent to me as a private message.
Do you know that person? Repeat his name and state whether or not you know him now.
Rusty LaFleur. I do not know him. I have tried to respond to him, and the account it says no longer available on Messenger. The account does no longer exist.
Would you spell his name for the court report?
RUSTYLEFLUER.
Now, could you determine when this video was uploaded to you, you received it on your phone, or the date it first came into your possession?
I don't recall the exact date. It was in 2023 sometime.
And is there any way you could look back and discovering this proceeding on your phone and tell when you received it with the exact date?
No.
Do you still have the same phone you received this on?
No.
Was this received on an old phone?
Yes.
What happened with that old phone it was received on?
I'm not even sure. It may have been put in the Walmart recycle bin for the phones where you get cash for phones.
Okay. And you customarily transfer your phones when you get a new one? You take everything and re-record it on your new phone?
Just transfer all data.
How many transfers of data have you done from 2020 to today for cell phone for getting new ones?
I've had 3 or 4 different phones in that time.
Okay, and each time you would take what you got and you transfer it to the new phone, correct?
Yes.
All right, now, do you have any way of determining what date this video was actually taken?
I uploaded it into a software called ChatGPT for analyzation, telling me everything it could extract from it. And it determined that it was recorded on an Android phone on May 21st, 2021.
May 21st, 2021.
Yes.
And where were you May 21st? Let's strike that. You have been coming to the Van Zandt County Courthouse for how long? What's the first time you've been in the Van Zandt County Courthouse?
Probably 2017.
So from 2017 through 2021, when this video you think it was recorded in 2021, did you frequent the courthouse on occasion?
Yes.
Now, you have had cases in front of this judge that we have the recusal motion on today, Judge Martin. You've had numerous appearances in front of him, correct?
Yes.
Do you remember the date of the judgment that Mr. Voss and Mr. Ritter and their law firm keep referring to? That is their permanent injunction that supposedly enjoins you and anybody else but the lady that purchased the church, Jamie. The lady, give me her last name.
Harbor.
I believe it's hard.
Excuse me?
Jamie Harbor.
Okay, Jamie Harbor. Thank you, whoever tried to help me. That injunction that involved Jamie Harbor, that was a permanent one that was stipulated that Mr. Voss referred to. Do you remember the date of that?
It's early July 2020.
So it was early July 2020. So this tape was recorded after that.
Yes.
Was there any other judicial rulings that you remember in any other cases after this May 2021 that you had with Judge Martin?
I had numerous. I've been at the courthouse numerous times.
Okay, do you remember a injunction hearing, which you had in Houston where you obtained a temporary injunction?
Yes, sir. Yes, sir.
Okay, now that temporary injunction hearing you had in Houston, there was a temporary injunction and then there were hearings in Van Zandt County, correct?
Yes, sir.
And Mr. Voss, he intervened in that case for the city of Canton, way over in Houston. And as a result of this intervention, this case about the injunction was transferred to Van Zandt County. You remember that?
Yes, sir.
And then there was a motion to recuse in that case. Do you remember that?
Yes, sir.
You remember what the date was on that approximately?
I believe that was last year sometime.
Last year sometime. That would have been in 2024 or 2025. Is that your recollection?
Yeah, I don't recall the date in that hearing.
In any event, can you tell us whether the recusal motion that this Judge Charles assigned himself to and was heard took place after May 2021?
Yes, it did.
To your knowledge, did anyone, Mr. Voss, Mr. Ritter, Judge Martin, any of his staff, bring to your attention any kind of comment having been made by the judge, allegedly, Judge Martin, analogous to, similar to, or containing the same words and spoken words that is displayed on this Article 13, this video?
No.
That you played for us?
No.
Now, excuse me? I'll proceed. As far as this video is concerned, did you suffer personal injuries from handling, we'll call it, by sheriff's deputies in the courthouse in Van Zandt County?
Yes.
Do you remember the date of that incident where you suffered injuries because they alleged they were helping to restrain you from harming yourself?
January 25th, 2020.
Now I'm asking about the date that you were injured in the Van Zandt courthouse, and I want you to think and consider my next question. Were you injured in the Van Zandt County Courthouse by handling by deputies before May 2021?
Yes.
Do you recall how long before May 2021 you were injured?
It'd be a year and 5 months.
So you were injured a year and 5 months before May 2021.
Yes.
Did you file suit in federal court about those injuries?
Yes.
Did anyone during the course of that case ever bring this video to the attention of anyone as evidence during the pendency of that case while it was disposed of?
No.
What is the status of the injuries that you received in the courthouse a year and a half before May 2021? Have you recovered from those injuries, and describe what they were?
I had injuries to my forehead that were inflicted by my phone, minor abrasions. I had a torn intestinal injury to my ileum in my stomach, or between the small and large intestine, that has repeatedly reopened, become infected over and over again. I need surgery on the intestine to try to heal this injury. It will not heal on its own. As a result of my injuries, I'm currently considered disabled. Doctors have determined that I'm disabled, and I've been determined disabled by the Texas Department of Human Services.
Did you suffer any other injuries in that instant?
Just the back injuries, back pain.
Do you know whether or not you have any kind of disc injury that occurred at the same time as the intestine injury?
They did not find any.
Now, since that date, you have continued to litigate cases in Van Zandt County, is that correct?
That's correct.
And you filed this motion to recuse, correct?
That's correct.
And you've seen this video.
Yes.
This Article 13 or Evidence 13. Do you feel like you have an unbiased judge or court determining your cases since May 2021?
I do not feel like I've ever had an unbiased judge when dealing with Chris Martin.
Now, it's getting back to the authenticity of this for a moment. Mr. Voss referred to something after Article 13. I think it was we'll call it exhibit or whatever. It's attached to your reply, I guess. What was that?
I'm sorry, repeat it. I lost your tracking.
What would have been the exhibit you attached after the video? What was that? It said, Mr. Voss said it appeared to be some kind of readout of some kind of description of maybe metadata or some kind of inscriptions that may be readable or at the beginning of the play of the videotape.
Give me a second here. I'm pulling it up. It is a Chat GPT print. It's a printout of a response from Chat GPT, which is an artificial intelligence software that can be accessed through Google Chrome browser.
Okay, now that has inscriptions of what that Chat GPT could locate reading the video. Is that your understanding of it?
I entered a command that said, I want you to analyze the attached video and create a short, concise report stating what it is and any information you can extract from the metadata. And it gave me a response.
Okay. Now, as far as anybody that wants to challenge or look at the authenticity of this video as having been taken in Judge Martin's courtroom, taken of Judge Martin, taken of his speech, and that May 2021 date, they want to challenge that. And your understanding what is the availability of sources to trace the authenticity of this tape.
I'm sorry, I didn't. Are you asking me a question or what are you
Yes,
asking?
I am. What can they do to go beyond what ChatGPT gave them in your understanding? Do you think that requires expert review?
Yes, I have no way to review it myself. All I did was upload the video file, and it gave me a printout showing what it found.
Now you've been declared you've been declared a pauper in this case, correct?
Yes,
You proceed without payment of costs, correct?
yes,
I'm not charging you anything for your representation here today, correct?
correct.
Now, you didn't spend any money analyzing this tape, correct?
Correct.
One of your options is to ask the court for money so you can spend it to analyze this tape. Have them appoint an expert, correct?
I don't know if that's an option in a civil case. It would be in a criminal case.
Okay. But you intend or have filed complaint against Judge Martin for official oppression, I should say.
I have sent everything, including the declaration, to the Texas Rangers, to the Texas Attorney General, and to Van Zandt County DA Tonda Curry.
Okay, but you're still in the process of preparing a complaint form that she requested that is an actual complaint form for the DA's office. Is that correct?
I have seen a complaint form. I have not completed it.
Do you intend to complete it?
Yes, I do.
You intend to file it?
Yes.
Now, with respect to that, did you ask Tonda Curry's office and the county, or in your process of asking them to analyze this video?
I have not asked them to analyze it. I have spoken with Tonda Curry on the phone, and she said to send whatever evidence I have, and she will look at it.
Okay, now, as far as this evidence is concerned, you have some familiarity with that 90-day requirement of retention of evidence and the government code that requires or occupations code or whatever it is that requires the county to keep things for 90 days, review them, and keep them if they have any evidence of criminal conduct. You familiar with that?
Vaguely.
All right. So the county has the option of reviewing this. This is not city records. This is county, as you understand.
That's correct.
Okay. Now, as far as this case is concerned, if this recusal motion is not granted, you're in a process of having more things ruled on by Judge Martin. Is that correct?
That's correct.
Now, specifically, they're going to rule on a motion that you're a frivolous litigant without any hearing at all, just under submission. Is that correct?
Yes.
And Mr. Voss and Mr. Ritter have set this up by their requests?
As far as I understand.
Now, if this recusal motion is not granted, this tape is before us. You're going to have the same judge rule on the recusal. I mean, the same judge is at issue in this recusal is going to rule on a frivolous litigant motion to keep you out of the courthouse permanently.
Yes.
As far as filing and appearing to argue anything in your own behalf.
That's correct.
Do you have the money to pay an attorney when you're a pauper every time you need to go to court for legal business?
No, sir.
Will you be effectively shut out of any place where you can make your arguments that the government, the city rather, is in trying to take over that property out there, that nursing home, without having to pay just compensation?
The way I understand it, it will bar me from all state litigation.
Means you can't even file a suit over here in Houston.
Yeah, that's correct.
You'd have to go to Van Zandt County to get permission from Judge Martin to file a suit here.
The way I understand it, yes.
And as far as
All right, let me correct. The way I understand it is I would have to request permission to file anything from the administrative regional judge which I believe is here present right now.
So you wouldn't go to Houston's administrative judge to get permission. You'd have to ask Judge Charles for permission.
That's the way it's been explained to me.
Okay. So as far as what we have going on here, you've continually for several years attempted to challenge the nursing home rulings that your church, the First Church and then New Beginnings and others, tried to convert into religious occupation for the homeless. And is there other disputes going on concerning the validity of the city's control of the church property?
Yes, sir.
What
Numerous.
is that litigation, and how might it be carried out here in Van Zandt County in the future?
There's several issues. Number one is the Constitution of the state of Texas that the voters amended. I was an integral part of getting the legislature to put this issue before the voters. I have met with Governor Abbott personally, and he said that churches can never be closed and that I can reopen my church. There is in the Constitution a guarantee that churches will never be closed. So that's the main issue here, is that Judge Martin has closed a church permanently through a permanent stipulated injunction and final judgment, which I am not a party to. They just non-suit dismissed me from the case and then went behind my back and got Jamie Harbour to agree to this permanent injunction that purports to bind me, according to Mr. Voss here, purports to bind the whole world.
Did Jamie Harbour ever pay for the property or keep her promise to pay taxes? Or
Okay. I think we're getting outside the scope of the motion to recuse and what's in the motion. Let's stick to the facts. We're not going to relitigate that case. That is not my role today. And again, you can't just Judge Martin's rulings alone are an insufficient basis to justify recusal. So let's stick to what is relevant to this particular recusal motion.
let me state for the record an argument. We disagree strongly with what you just said as being the law. The rule is generally cannot be the basis for a recusal. And why do they have the generally provision? The reason why is a whole bunch of unexplainable, unfair rulings that are alleged to be made by mistake, which are coupled with video evidence like this. And
Mr. Eisen, Mr.
raises an evidentiary presumption. Thank you very much, sir. I pass back.
Mr. Eisen, in the future, when I am trying to talk, I would appreciate you stopping. You know the rules as an attorney. I was not trying to cut you off, but I wanted to make a point. All right. Again, the rule is that it must not be solely based on a judge's rulings in the case. Obviously, that you have some other evidence that I will consider. But again, as far as what the rulings were in the past cases, that is not for me to consider or reconsider. You understand? All right. Have you passed the witness at this time?
May I confer with my witness briefly? And I think I have, and I think we've accomplished the goal of the attorney and the judge controlling the hearing. Mr. Donaldson hadn't made any input, so I request the ability to speak with him short, with a brief break, and then we'll get back on. I think I can rest.
All right. I'll give you a few moments.
Appreciate it. Let me know when you're there. He didn't put us in a box. He just gave me time to talk, so make sure I'm on mute. I'm on.
Hang on. Let her mute you first. All right. Where'd Mr. Eisen go? Mr. Donaldson, if you'd call your attorney and ask him to get back on the Zoom.
I'm doing that right now.
Okay, never mind. They moved him to a breakout room. They're moving him back.
Joe is not on screen. All right, bye.
He's been moved out of the breakout room. There we go. All right.
Yes, sir. Mr.
All right, Mr. Eisen, you may.
May I proceed with this?
Yes.
We make an objection as follows to the conduct of this hearing, the way it's being conducted. I understand that if it's going to be a public hearing, all members of the public should have access. My client informs me, and I'm blind, but he informs me that a Mr. Dow is attending this hearing. And if he's attending this hearing and he's getting special privileges to attend the hearing, and it wasn't made open to the public, we object. Because if this hearing was closed, the only one we've been able to bring in is parties. And we haven't brought in any witnesses. So we object to that. I don't know what Mr. Voss and Mr. Ritter can say about that. And I don't know what their connection is with Mr. Dow. But I know Mr. Dow to be involved in litigation with Judge Martin that had recusal motions involved in it. And so we, again, want administrative fairness in the way the hearing is conducted. And with that objection, I'm going to pass to Mr. Voss. The opening part of my case is closed.
All right. This is my understanding. This hearing is being broadcast in the district courtroom, the Van Zandt County, the 294th District Courtroom. And so anybody who is in the public could have come in and watched it.
Okay.
All right. So your objection's overruled. Mr. Voss, you may proceed.
Thank you, Your Honor. Mr. Donaldson, you testified that you obtained this video from Mr. LaFleur. Do you remember when that was?
Sometime in 2023.
All right. And you posted this video on the Facebook page concerning God's Property Mennonite Fellowship. Do you recall that?
I do.
And that date was March 11, 2025. True?
True.
So you've known about this video since that time, is that right?
I'm going to before I confirm the true, I'm going to verify that that's when I posted it, yes.
And you testified you did not make this video. Did I hear that correctly?
That is correct.
Do you know who recorded the video?
I do not. I have a reason to believe that it's a troll that's been harassing me on the internet named Timothy Spurgeon.
But you don't know that for sure, do you?
I do not know who made this video. I do not know who Rusty LaFleur is. I know that I've tried to message the account back and it doesn't exist anymore that it came from.
Do you know why this video was recorded then?
I'm sorry?
Do you know why this video was recorded?
No, I do not.
Do you know what the circumstances were surrounding its recording? As in where it was and what was going on?
There are nothing identifiable on there but Judge Martin. I do not know where it was recorded. I do not know how it was recorded. It appears to be black and white, so I was thinking it was a body camera.
Do you know about any other parts of the recording that exists before or after the snippet you provided us?
It says that there are no other parts of the recording. It's a complete file from beginning to end.
Well, what says that?
The ChatGPT analysis.
And you're referring to Exhibit 14? Attached to your declaration.
Yes.
There's no person that signed this ChatGPT declaration or paper, is there?
No.
In fact, at the end of it, it says that this is not even a declaration style or a court-ready exhibit, doesn't it?
Yes. I am not a...
Okay, you answer my question, excuse me. Mr. Donaldson, do you know if what kind of equipment, other than what the ChatGPT said, what kind of equipment it was recorded on?
No.
Is there any opportunity to compare the copy you received from Mr. LaFleur with the original?
Do not have the original. All I have is the file that was sent to me through Messenger.
Do you know who it was Judge Martin was talking to in the video?
I do not. No, it's it's inaudible.
In other words, you can't hear any kind of whatever response was made. You can't hear it.
No.
Your Honor, that's all the questions I have. I'll pass the witness.
All right, redirect.
No, I don't have anything further.
Okay.
We can move to argument.
All right. So, Mr. Eisen, you rest your case.
I rest my evidence, but I offer the video. And that has already been in without objection because it was attached to the reply, Mr. Donaldson. That's the position we take, but also reoffer it.
At this time, Judge, then I'm going to lodge my objection to the video.
You may place your objection.
The city objects to this purported video because it lacks adequate foundation and does not accurately portray the situation depicted. Further, that's attachment number 13 to Mr. Donaldson's declaration. The city also objects to attachment number 14, which is the Chat GPT document as a purported report that has no characteristics necessary to establish any kind of expert witness testimony under Rules 702 and 703. There's no name, there's no credentials, it's unsigned, it's unsworn, and itself admits that it is not a court-ready exhibit on the second page. The video, frankly, presents a suspicion that it may itself be an AI-generated video, at least in our mind. But what is lacking here is any evidence to really provide the authentication required, because the grounds for admitting a video are really the same grounds necessary for admission into evidence as for photos. And for that proposition, I cite Kessler versus Fanning, 953 Southwest 2nd 515 at page 522, a Fort Worth appellate case from 1997. The authentication elements that needs to authenticate a video is number one, the recording system and the components itself that need to be established, linking the date and time. Number two, the manner and process used to make the video and copies of it. Number three, evidence needs to be provided from a witness, authenticating witness who viewed the original and the copy to verify its accuracy. Number four, there needs to be evidence of who recorded the video, where it was recorded, when it was recorded, how it was recorded, etc. And lastly, that there needs to be evidence that the video is an accurate portrayal of events as they were existing on the date and time presented. For those list of elements, I cite Theory, Thierry versus State, 288 Southwest 3rd 80 at page 89. That's a 2009 Houston 1st District appellate case. So that the court is clear. Our objection is that since the video has not been properly authenticated and there's no evidence that can properly authenticate it, that it be excluded from evidence because it's inadmissible and thus doesn't constitute any evidence whatsoever necessary for the recusal motion before the court. That concludes the city's objection to the video.
Okay.
All right. Mr. Eisen, your response?
My response is I'm going to ask Mr. Donaldson 2 questions for further predicate. Mr. Donaldson, how many times have you been in front of Judge Martin?
You're muted, Mr. Donaldson.
He's muted, Bab. Repeat my question.
Muted. All right, am I unmuted?
You are unmuted now.
All right. I don't remember the question, but while we've been talking, I have just asked ChatGPT to reformat it into a court-ready declaration, which I am signed.
Let me handle this, Judge Charles, if you will. We may be able to submit that later, Mr. Donaldson, but we're in a hearing right now, and I need to proceed with 2 questions on you, and then I need to proceed with the argument. Have you been in front of Judge Martin many times and heard him make rulings?
I have.
Can you compare the voice on this tape, the audible portion, and state whether or not you're familiar enough with Judge Martin's voice to tell us whether that's Judge Martin's voice, as you remember?
Yes, it is.
That's all the questions I have. Now I'll move to my argument. Mr. Voss's argument about video misses the point. We're in a recusal hearing. This is not the strict rules of evidence where criminals get off or people get off because the issue is guilt or innocence, preponderance of the evidence of proving operative facts to show liability or guilt. This is a recusal hearing. And the question here is impropriety. And if there's any ambiguity at all in this evidence, the court must lean toward granting the recusal and preserving public confidence, which quite frankly has been
Mr. Eisen,
Van Zandt County. So,
Mr. Eisen, let me interrupt you for a second. The rules state under Rule 18A, subsection A4, that the evidence or that the motion itself must state with detail and particularity facts that are within the affiant's personal knowledge, but secondly, would be admissible in evidence. The rules of evidence apply to a recusal hearing.
well, I did disagree with the court's point. I believe it's been interpreted different. I'll move on and state that. Go ahead. Ignore this video evidence. It's not going to go away. You can assign yourself all you want, but this video is going to remain. And not only that, the audible portion is going to remain. And we've been dealing with video about 20, 30 years in my 48 years, but we've also been dealing with sound recordings much longer than that. And so this video, if it was just a tape that was put forth, there's enough evidence here to admit it from our standpoint. And here we have proof, if it's true, of horrible things that have occurred. Sickening. It sickens this attorney.
Okay.
And I remind this court that the court has responsibility to bring any ethical violations to the attention of the authorities.
Mr. Eisen, please. I was only right now. I'm not going into your closing argument. Yeah, I'm not asking for your closing argument yet. I'm asking for this was argument. No, I'm asking for your response to Mr. Voss's objection as to the video itself.
Okay, then I'll limit that and go into the argument later. My response is the audible portion of it has been identified sufficiently to come into evidence, just like handwriting. The recognition of someone's voice, that's been established, that could be argued. And then also, we've asked for discovery. They don't get to have a ruling on this without discovery. Is the court's interpretation of Rule 18A that no discovery is allowed in recusal hearings? I think not. Nobody has provided such discovery. They took the precaution, I guess Mr. Donaldson did, pro se, of asking for a brief period of discovery. What should be done? The county should have to say whether or not this was ever recorded, whether it was destroyed, and explain what happened to it and put their experts on it. It shouldn't be Mr. Donaldson's liability and burden in this particular situation in light of this evidence. The burden is just too heavy. So we say grant our motion for discovery, rule on Mr. Voss's and Mr. Ritter's objection later. Let them have their crack at it with their city experts. Maybe they can gender up the fact that somebody spent an enormous amount of money to make this video in order to try to embarrass Judge Martin. I think that the record in that regard speaks for itself. So I again stress we want discovery. I again stress that the sonic portion, the audible portion of it is admissible. I do concede that authenticity, we cannot prove it to the 5 provisions of the best evidence rule relating to video. I do not believe it's necessary in a recusal hearing. And so I differ with the court on that, but that's it. That I'm fully submitted on his objection.
I am going to sustain the objection. This video has not been authenticated under the rules of evidence and under the established case law. There is nothing to show that it is authentic. The person who made the recording has not testified. And there is, in this day and age, there's nothing to show that it is not AI generated. So therefore, at this time, I am going to sustain the objection as to the video. You may proceed with your argument.
Well, I don't have much more argument on that. I would again stress that the court should not have reassigned itself to this matter. I know in the past, the record will show by judicial notice of the cases that you've sat on. You've done this numerous times with Judge Martin. And we believe that we asked this question. You allow Judge Martin to continue in this. Is this evidence of impropriety enough to undermine public confidence? The answer is indubitably yes. So whether you admit this video or not, there's a state of evidence now in the state of these proceedings that undermines the confidence of Van Zandt County and the public. And
well,
this,
Mr.
is Eisen, this is not the only video.
Mr. Eisen, please, again, during your argument, I do have the right to ask some questions. Let me ask this question. All right, Mr. Donaldson testified he's had possession of this since 2023. There have been 3 other, I'll take judicial notice of 3 other recusal hearings that I have heard from Mr. Donaldson involving Judge Martin since that time. I heard one on April 23rd, 2025. I heard one on May 17th, 2024. Excuse me, just two additional hearings.
Could you repeat that, please?
I heard a motion to recuse Judge Martin filed by Mr. Donaldson on April 23rd, 2025 in cause number 19-00185. And I heard a motion to recuse on May 17th, 2024 in cause number 23-00154. My question is, if Mr. Donaldson has had possession of this videotape or this video since 2023, how is this even timely filed when he obviously knew about it when he filed this new lawsuit?
That's not, you finished?
Hang on. Let me finish.
Go ahead.
It was never brought up in the other 2 recusal hearings. So how is this even timely filed, and how is this issue not waived?
How? Well, in the first place, under canons of judicial ethics, you shouldn't be arguing this case for the other side. You gave a perfect argument for Mr. Voss that he didn't make.
No,
and so
Mr.
thank you for representing the other
Eisen.
side in this case, and
Mr.
we object
Eisen,
to that. But the comment on that is Mr. Donaldson, number 1, is not an attorney. Mr. Donaldson, number 2, is ignorant of the laws, and so is Mr. Birnbaum. Answer is number 3. When I was requested to take this case and this came to my attention, I am presenting it. So blame me because I made my appearance now on this recusal. I had my other appearance in this recusal, another one you reassigned yourself to, and I didn't bring it up then. I didn't know about it then. So that's the answer to your question. And so about waiver, no, waivers have to be constitutionally, when you're denied due process, waivers have to be intentional, knowing, and we don't have such a waiver. So good argument for Mr. Voss, Judge Charles, but it fails on those grounds. And that's my response.
Okay. Thank you, Mr. Eisen.
Thank you, Judge Charles.
Mr. Voss, you may proceed.
Thank you, Your Honor. By way of closing argument, I won't belabor the city's position too much. I will refer the court to the city's response to the plaintiff's motion to recuse that was filed in this case on Get the date. The 9th of February. In it, I addressed each of the 5 grounds that were asserted by Mr. Donaldson and rebutted each of them because there was a lack of evidence to show that Judge Martin has created a condition of, or a question of impartiality by his actions. There is no evidence to support that. The only evidence that has been presented, besides the video that has been not admitted into evidence, are Donaldson's complaints with the court's rulings in the underlying cases. And I submit that those complaints are simply those of a dissatisfied litigant and not someone that is able to show that there's some sort of improper bias or prejudice by Judge Martin. So I urge the court to deny the motion to recuse.
Rebuttal argument, if any, Mr. Eisen?
Yes, my rebuttal argument is we again lodge your objection for this judge sitting on this recusal to represent the opposing counsel, represent the opposing side, and attempt to construct a waiver out of the evidence. It's totally improper. It's itself grounds for recusal. But that's a matter for another day. And I state that we again stress you should not make any ruling until there's discovery, because I have this sneaking suspicion that this, like all this other whistleblower evidence, is going to be proven to be authentic. And then all those that tried to cover it up will have to be answering a lot of questions. That's what I think. And I base that on my IRS experience with Dixon versus Commissioner, where the IRS bribed witnesses and the tax court had to refund millions of dollars to taxpayers. And I base it on all my prior experience in dealing with this kind of evidence, even back to the first Medellin cartel case in Florida, where we wore headphones and had 30 defendants. That's it.
Your Honor, may I
I'm finished.
consult with my attorney one last time? Your Honor, may I consult with my attorney one last time privately? Hello?
Yes.
I'll give you a couple minutes, but that's it, because unless there's something else that's going to come, there's no reopening of the evidence. So
No, I don't need any
a couple
reopening of the evidence. Thank you. Thank you for accommodating us.
I'm not going to put you all in a breakout room, but I just want Mr.
Are
Eisen.
you putting us in breakout room?
No, I'm not. I'm not going to put you in a breakout room. Just ask your assistant
Okay, I'll mute it and
to
take the
mute
video
yourself.
down.
Yes.
Hello.
Okay, we can hear you.
You can hear
All right,
me?
then.
My
Yes.
client has requested that I make an oral motion to recuse, Your Honor, from making this recusal ruling. I'm going to not make that, although I'm normally bound by the instructions of my client. I've instructed my client he'll have ample opportunity to make such a motion in the future or whatever, or appeal bias on the record that does not need a recusal motion. And due to the background of all this cases and things, I'm not going to make such an oral motion, but he requested I do so. He requested also that he be allowed to make the motion himself if I did not do so. We're staying within the ambit of the rules now, but we're on a borderline because my duty to handle this recusal hearing has ended with the closing of my argument. If he has the status, I don't know, to make an oral motion, he can do so. I'm not saying I don't think you shouldn't have recused yourself, but I filed an opportunity for you to consider the reassignment, and that's as far as I wanted to go on this record. So that's it. That's where we are.
An oral motion to recuse is the equivalent of no motion at all, and I'm not going to recuse myself. All right. I have heard the testimony, reviewed the motions, the responses. Court makes the following findings and ruling. court finds that the motion under Rule 18A, subsection A, is verified, that it states at least one of the grounds listed under Rule 18B. The motion itself is not based solely on the judge's rulings, but we'll come back to that, and that it must state in detail and particular facts that are within the affiant's personal knowledge, except that facts may be stated on information and belief if there is a basis for the belief, and then it's specifically stated, and would be admissible as evidence, and if proven would be sufficient to justify recusal. The main piece of evidence was the video. The court has found that the video, that it in itself was not admissible because it was not properly authenticated. Even if it was authenticated, the time for filing a motion to recuse, it must be filed as soon as practicable after the movement knows of the grounds stated in the motion. Mr. Donaldson testified he's known of this video since 2023. There have been other cases that he has filed motions to recuse that he never brought this forward. If this was proper grounds for recusal when he filed his original lawsuit, in this case, he could have filed a motion to recuse. But this motion to recuse was not filed until January 26th of this year. Court finds that even if the video was admissible, that the motion was not, that issue was not timely filed because it was not filed as soon as practicable after the movement knew of the particular issue. The rest of the motion that Mr. Donaldson filed, there's been no evidence raised other than rulings, and again, those are insufficient to justify recusal. Therefore, at this time, I am going to deny the motion to recuse. I will prepare a written order this afternoon and have it emailed to all the parties.
No. We need a ruling on the discovery also, Your Honor.
I find that there was no need for additional discovery in this case. Further, that motion for discovery was not filed until a few hours before this hearing was scheduled, this hearing was to be heard. And so therefore, I denied that motion for discovery.
No. Those motions don't have any requirement. Recusals set on a short basis, short notice. There was only 3, 4, 5, 10 days necessary to file that motion. So again, you're practicing law. You are attempting to represent the city. They never made these arguments. We object to that. Thank you for your ruling.
You're welcome, Mr. Eisen. I'm not going to engage. Nothing further. We are adjourned. This hearing's over.
Your Honor,
Thank you.
Your Honor, may
Yes.
I briefly put something on the record?
You may, Mr. Rip.
I need to put this on the record that Mr. Donaldson messaged me directly at 12:14 with the following: I am not going away until my personal property is returned and I'm either given back the real property I paid for or paid for it. You block me out of the courts and leave me with no remedy, then I will be under duress and have additional rights under common law. Remember that. I see you making faces. Feel the need to preserve that on the record for any future, for possible future events.
Yeah, let me make a statement about possible future events. None of these gentlemen have been beat up and have their intestines punctured with their discs in their back. And none of them have seen any kind of evidence like this. And I make that representation for future reference and events.
This point, this hearing is over. There's
Thank
nothing
you.
further. We are
Thank you, Your
adjourned.
Honor.
Your little ass is in this up to its neck, Charles. You're going to get a judicial complaint against you now for representing the other side.
Joe, they're still here recording this.
Well, let him go. He released us.
Yeah, but
I'm released. I can say anything I want.
the District Court of Van Zandt County is still recording this. this meeting? Ms. Barker, are you going to sign off or are you going to leave this hearing running?